Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and a lot of my practice is suing abusive debt collectors, and I thought it might be helpful to give you kind of the big picture. We won't go into all the details. We can do those in separate videos, but just the big picture of what happens when we sue an abusive debt collector. So we're not talking in this video about what exactly violates the law and all that type of stuff. We're saying we're dealing with the debt collector. They have violated the FDCPA, the Fair Debt Collection Practices Act, and now we're suing them. So what happens? So I personally, and this is how I train other lawyers to do it around the country, is I personally file those cases in state court. And part of the reason is there's some silly arguments being made in federal court about standing under a case decision called Spokio, and I won't get into all that here. But we file them in state court. 99.9% of the time. Then after the defendant is served, so we filed the case, they're served, they have 30 days to respond. They also have 30 days to what's called remove the case. That's to take it from state court over to federal court. And 99.9% of the time they do that. So it's in state court, Alabama state court, and it gets removed or transferred to federal court. Well, now what happens when it's in federal court? Well, it would be the same as if we just filed it directly in federal court. The defendant, the debt collector we've sued, they either will answer the case or they will move to dismiss the case. And a lot of times they move to dismiss, even when there's no basis for it. Look, it makes the lawyers money and it makes the debt collectors happy because it looks like they're fighting us, okay? So they file this 30-page long motion to dismiss. They say, Judge, there's this nothing to this lawsuit. It's terrible. There's no way that the plaintiff, the consumer, can win. So just throw the case out. Well, when we get that motion to dismiss, we can either respond to it and say, actually, it's a perfectly pled case, or we can amend our lawsuit. We have the automatic right to amend the lawsuit. Well, typically what we do, even though we don't think we have to amend it, if they have filed a motion to dismiss and they say, here are the 3 things that are defective about this complaint. Okay, well, we'll just amend. We'll make it more clear. We'll put more detail in about those 3 areas. Okay, so it's kind of silly, but anyway, we do that, and then usually after that, they answer the lawsuit. Okay, so let's get to the answer. Remember, we filed the case. The defendant was served. They were handed the lawsuit. They removed it to federal court, and now they've answered the complaint. So what happens next? Well, typically we do what's called the party planning meeting. And that's where the lawyers get together, whether it's in person, by Zoom, by phone, whatever it is. And we plan out the schedule. And we know for each individual judge kind of what they like. You know, do they want us to have a long period of time or a shorter period of time? And we just make a proposal to the judge and we say, Judge, here's what we propose in terms of the number of depositions, the length of time we have to conduct discovery. That's where we're exchanging information, questioning each other. Well, all those dates in there. Then the judge gets that, and the judge may say, I totally agree, or I want to expand it or contract it. And then the judge will enter what's called a scheduling order. Now, as soon as we have that meeting, we can start discovery, which means we can send them questions in writing. So those are interrogatories, like we're interrogating them in writing. We can request production of documents. So we say, hey, we want all these documents from you. They can say the same thing from us. We can do requests for admissions where we're saying, hey, admit or deny that you called my client on this date and time. Admit or deny that you credit reported, XYZ about my client on such and such date. So these are very specific factual details that we want the other side to either admit, and then we don't have to prove them, or deny, and then that gives us the basis to really pursue that in deposition. And if they say, oh, well, that's not relevant, we go, yeah, you denied it over here, so we have to prove it by questioning your witness under oath. And also depositions. That's where we are questioning people under oath. They're questioning our client under oath. It may be non-parties that we do by subpoena, that we question them under oath. And then once we're done with all the discovery, then we get to what's called, sometimes it's called the dispositive motion stage. more commonly known as just summary judgment. And that's where either we can ask the court for summary judgment and say, look, there's no need for a trial on whether or not this debt collector broke the law. You can just enter judgment on that. Now, usually we want the damages to be the jury to determine that. And the debt collector can say, hey, I think I'm entitled to summary judgment. There's no way that a reasonable jury could ever say we did anything wrong. So just throw the whole case out, summarily enter judgment. Okay. So again, we file a suit, they're served, they remove it, they answer, we do discovery, we go through summary judgment, assuming that there's still something to try the case, and normally there is after summary judgment, then we go to trial. Well, right before trial, we'll have what's called a pretrial hearing. That's where the judge wants to know, hey, what are the issues? Do we have any arguments that need to be made about evidence that needs to be kept in or kept out? And those are typically called motions in limine. And then how about jury charges? How are we doing that? And then we actually get to the trial. Now, when we get to the trial, and again, I'm happy to do a video that covers the trial in more detail, but just from start to finish on a trial, we pick a jury, and then the judge will have some opening remarks, and then the plaintiff, the consumer who's suing, gives an opening statement. And that's where we're laying out for the jury, here's kind of a roadmap of what's happening. Okay? And then the defendant, the debt collector, they give their opening statement. And then because we bear the burden of proving our case, we go first. We call our witnesses. And so that may be our client. It may be the debt collector who made the call, maybe the debt collector's what's called corporate representative, the person that's sitting there at the table. So usually we call all of their witnesses in our case, and there's some strategic reasons for that. And we question them. After we're done questioning each witness, then the debt collector can cross-examine the person that we called. And then we're done with that person eventually, and then we call the next person. And when we're totally done, that's known as the plaintiff resting. We say, I have no further witnesses, Your Honor. Usually at that point, the debt collector will move for judgment as a matter of law and say, there's no reason to go any further. Based on all the evidence that the consumer brought forth, they still lose. Well, presumably that gets denied. I mean, if we've gotten to this point, I would like to think that we know what we're doing in trial. And certainly every jury trial we've ever had involving a debt collector, we've gotten past the judgment as a matter of law. And now the defendant, the debt collector, has its opportunity to call witnesses, put evidence in. And then when they're done with that, they usually move again for judgment. That's denied. And then we pick out the jury charges, although usually in the jury trials I'm involved in, we've already done that, well before the trial. And then the judge will charge the jury, which is just to instruct the jury, here's what the law is. And then the jury has the case. And they go back in the jury room and they deliberate, and then they come back with a verdict. And then if either side is unhappy with that verdict, they may have the right to appeal that. So hopefully it gives you kind of a big picture from start when we file the lawsuit to the jury verdict, and the case is now over unless there's an appeal, and everything in between. And if you are interested in me going into more details on any of these kind of areas, or maybe one big video on all these, just let me know and I'm happy to do that. But I just wanted you to have, hopefully this is like, I don't know how long I'm talking, maybe 10 minutes or something, a nice overview of what happens when we sue an abusive debt collector under the Fair Debt Collection Practices Act. Okay, guys, thanks for watching this. I'll catch you in the next one. Bye-bye.